Content warning. This episode contains discussion of the murder of children.
So in the aftermath of the release of the probable cause affidavit in the murders of Abigail Williams and Liberty German, the murder sheet heard from a number of experts who reached out to sort of lend their expertise on what the information was included in the probable cause affidavit. So we're very grateful and gratified for that.
One of the experts we heard from was a veteran defense attorney with many, many years experience in handling serious cases, including murder cases, including capital cases. He offered to come on and share with us and you his perspective on the value of the evidence in this case. This attorney we spoke with is still actively practicing. Because of that, he asked that we not include his name. Obviously, we know his name, and we were able to verify that he is who he said he was, and he does indeed have the experience he claims.
So in this conversation, we'll be getting at that, and we also continue to welcome more experts to come forward and let us know what you think about some of the information contained in the probable cause affidavit. Obviously, as we say at the top of the shows where we're talking about the PC, a probable cause is not the prosecution's entire case, but we feel it is relevant to talk about because it contains a lot of information that might be kind of indicating where the case could be going. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
We first connected while looking into the Burger Chef murders, an Indiana cold case. Together, we built a spreadsheet documenting hundreds of cases of restaurant-related homicides. That original spreadsheet gave way to our podcast, The Murder Sheet.
Now we maintain that same research-centric, investigative approach as we look into all sorts of homicides, including unsolved cases, historical crimes, and, of course, restaurant murders.
We don't just chat about the headlines. Our podcast is a platform for our journalism. The Murder Sheet focuses on investigative reporting, thoughtful analysis, thorough research, and in-depth interviews.
We're the Murder Sheet.
And this is the Delphi Murders, a defense perspective on the bullet.
I said I'd let you ask questions, but there is, from somebody who's done this kind of work, I can tell you there's a whole bunch more that they are not putting in there. There's no doubt about that. Because this, what is in, I've not read it thoroughly. I've listened to different, verbal versions of it on YouTube, people reading it. And so subject to me overlooking something in it, this is incredibly unique. You would, but anyway, you ask questions and then I'll come back. I'll make sure I say what I want to say along the way.
Absolutely. Tell us about this evidence in your experience as a criminal defense attorney. Is this strong ballistics evidence? Can you just kind of talk us through that, how it's considered in the criminal defense world?
Incredibly weak. And what people commonly call ballistics is really tool mark examination. If someone scratches a surface with a screwdriver, that's a tool mark. If somebody cuts something with a pair of scissors, that's a tool mark. And the tool mark that is being made in this process is typically when a bullet goes down the barrel of a gun, there's rifling inside the barrel. There's no rifling in a shotgun, but in long rifles and pistols, there's rifling. Like when you throw a football, you want it to spin so that it is stable in flight. And different manufacturers have different grooves, numbers of grooves. Some are right-handed twists, some are left-handed twists. There's all kinds of ways to know when you see the bullet gets fired that there are ways to narrow it down. But that's not what they're talking about in this case. They're talking about an ejector. So what happens inside a gun is when the trigger is pulled, there's various mechanisms, but to boil it down, when the trigger is pulled, a firing pin hits the back of the cartridge, and the bullet, the firing pin causes the gunpowder inside the cartridge to explode, and the bullet moves forward rapidly and then goes through the barrel, and the rifling is grooved into the bullet as it goes through the front of the gun. When that process happens, the cartridge remains inside the gun. In the old days, you had a revolver, you'd have to twist the barrel and physically pull it out or turn it up, and you've seen that sort of thing theatrically. But in a gun like a modern semi-automatic gun, what you have is something that a piece of metal that strikes the empty cartridge from the side and pushes it out. So, and that's what makes it easy to fire quickly. You pull the trigger, and then the bullet goes out, and then the ejector, half second later, really milliseconds later, hits the side of that cartridge and pushes it out the side of the gun, and another cartridge comes in to the chamber, and then you can pull the trigger again. You don't have to turn the revolver. You don't have to do anything manually. That's why it's semi-automatic. That ejector is not like the rifling in the barrel. The rifling in the barrel it has grooves, and it's multiple grooves, and you can tell a lot by the number and the direction of the groove that's burned into the bullet. The ejector is just a flat piece of metal. Sometimes it's round, but sometimes it's flat, and it hits the cartridge, and it just pushes it out of the way. But it hits it hard enough to make a little mark. Well, it doesn't have enough characteristics on its surface to make a hard and fast determination whether it came from a particular gun or not. Now, that's the defense perspective. The prosecution says, "Oh yeah, we can individualize from this one particular impression." But I believe personally that is just completely incorrect, because there's just not enough information there. It's like saying you can individualize because, a white male was seen doing a crime, so this white male must be the one. You don't have enough information. You can maybe not exclude a gun, right? You can say this gun could have made this mark, but there's just not enough information to be able to say for sure. It's like another example would be a DNA test. If you have, out of the 16 standard markers, if you have one marker that matches the suspect, but you only have one marker in your sample, all you can do is say, well, it could be, but you can't match until you get more information. And the way that the ejectors work, in my opinion, you're never going to have enough to say this is the gun to the exclusion of all of the guns. And there is there's a lady that, and I can send you a website later that you can, but there's a lady up in the Northeast somewhere who I went to a conference who has extensive research about even ballistic, what we call ballistics, out of the barrel of the gun is not even good science. But the ejector is far weaker than what goes through the barrel.
And that's even if we're looking at the ejector mark, under a microscope and looking at it up close. Is that correct?
Yes. Now, okay, so if there's a defect on the ejector, if there's a little scratch on the ejector that's deep enough that it will leave an imprint as it's the cartridge, Well, maybe you can say then that it's like if you see somebody smile and you say, oh, they have a tooth missing. You can see it, right? There's a defect in what the impression that's going to be made on the cartridge. But if you have just a standard ejector, it's just going to look basically the same as every other ejector.
That makes sense. One thing we understand is that Rick Allen's gun was purchased by him in 2001. Do you know that if the gun is a bit older, it's more likely to have a defect, or would that be just a luck of the draw thing from the manufacturer? There could be a defect from the manufacturer, but if there's a defect, it's almost certainly something that happened later. It would be something that maybe improper usage, or maybe it jammed several times. There may be maybe it was something that happened when he was cleaning it. An older gun can have defects, just like an older car is going to have a dent. It didn't come from the manufacturer that way. It just through its life, it can obtain that defect.
What if theoretically we were able to prove to everyone's satisfaction that the bullet found at the crime scene could be linked to Allen's gun? What sort of significance would that have in your mind?
In my mind, it's still incredibly weak evidence, because there are so many ways that a cartridge an unspent round can go through a gun and be ejected out. It could be that it jammed at the firing range and kicked it out and it fell and somebody else picked it up. It could be that somebody came over to his house and saw it laying in an ashtray in the living room and just picked it up, played with it, put it in their own pocket. It could be that it fell out of a car somewhere along the way and somebody picked it up and, cleaning up highways, and dropped just because it was people have all kinds of things they put in their pockets as good luck charms, or, it could even accidentally have been placed there during a struggle. It could have been purposely placed there by somebody who's trying to set Rick Allen up. To me, the fact that even if it went through his gun, it's almost useless information, because you don't have to clear it right there on the spot. It could have been cleared out of that gun back in 2001 or whenever he first bought it. So it tells you nothing about how long ago that cartridge unspent round was cleared from his gun. It's meaningless evidence to me.
And just to play devil's advocate for a second, because I don't know what the forensic ability would be on this, but are there ways to tell how old a bullet is, or if it's been out in the elements for a while? It depends on what cartridge, what round you're looking at. But if it's been out in water for years, it's gonna, there's gonna be rust on it. There's gonna be tarnish, and if it's really, really bright, it hasn't been there long. There's ways but there's nothing that's really scientific. It's just an eyeball test. Yeah, that round has been there for a while, or no, it hasn't. That makes a lot of sense. And as far as, courts go, when you're practicing criminal defense, and I know it probably could depend on the location and whatnot, but are these kind of ejector marks, do you frequently see them brought up by prosecution as some sort of evidence in a trial?
In 20 years of practice, I've never seen it come up, ever. The tool mark examination reports regarding the markings that are left on a bullet that went through a barrel, I've seen that often. I've never seen an ejector or ejector markings be an issue in a case, ever.
We always love to cover a good historical mystery on the Murder Sheet, so it's not a huge shock that our favorite game is all about a 1920s detective, hot on the trail of all sorts of strange happenings.
We're talking about June's Journey. It's a free-to-download hidden object game, and it's utterly delightful.
You play as June Parker, a sleuth from the 1920s. In each level, you inspect scenes for hidden clues.
I play so much that I'm already on Chapter 12. To advance levels, you get to decorate your own personal island estate. I love collecting different features, like a beautiful swan pond, a swirling windmill, and a gaggle of old-time reporters. I'm very proud of all of those. Whenever I'm solving mysteries, I get to travel everywhere from Cuba to Paris to Italy to investigate cases involving artistic scandals, blackmail, and murder most foul.
One thing that makes June's journey special for me is the lovely artwork underpinning each level. The attention to detail really makes each scene come alive, and the characters are packed with personality. It's really immersive and makes us feel like we've been dropped into an old-fashioned mystery story.
I can get a bit antsy whenever I'm stuck waiting in line or on hold during a call. June's Journey is a great respite, a chance to play a fun game and get a mental boost while I'm at it.
Find your first clue by downloading June's Journey today. Available on Android and iOS mobile devices, as well as on PC through Facebook Games.
In your expert opinion, what could it mean that they're using them in this very high-profile case?
Well, I appreciate the word expert. I don't know that I'm an expert, but I've done a lot of this work. And what I think is that they're using this information to get a probable cause finding without having to reveal other information.
Yeah, that makes sense. Do you think that, you mentioned that the tool mark identification, technology and things around that is a little bit more contested than a lot of civilians may realize. And could you speak more to that? Is it starting to get a pushback in courts in America in general?
In the jurisdiction where I practice, it's not being contested very much because it's not used a bunch in the courts where I'm at. But I know that there is a trend towards fighting this kind of information from the defense perspective. There's a trend in fighting it nationwide. I go to conferences all over, and I know that, particularly in the Northeast, there have been some cases where it has been excluded. And we're talking about the more specific tool mark that is imparted by the barrel is far stronger than the ejector. So the tool marks in the barrel evidence is being contested quite vigorously around the country in other locations, and with some success. And I will take a step back and say, since the 2009, I never can remember if it's 9 or 7, but the National Academy of Sciences report that came out regarding forensic sciences, since that report was issued, there has been a lot of general contesting of what was otherwise considered ironclad forensic evidence. We're supposed to, believe the science is what people were saying, in with the COVID stuff and all of that kind of stuff. But what in the defense side, it used to be that, well, a fingerprint is a fingerprint and DNA is DNA. But that National Academy of Sciences report said there's really only one forensic science that has any capability of individualizing, of saying a person, an individual person left this particular piece of evidence, and that is DNA that is large enough to exclude other people and single source biological samples. That's the only thing that the National Academy of Sciences said is capable of individualizing with any degree of So we're talking about, if you think about it, even fingerprints are not strong evidence according to that report. But particularly these tool mark examination things, I think are. I think people are in the defense community are starting to realize that this, just because somebody gets on a witness stand and says they're an expert in something, doesn't make it true. Just seen too many experts in various fields being excluded and having controversies related to their opinions to accept that as evidence in general course in defense of a case.
Do you envision that in this case, obviously there's a lot of unknowns at this point, but let's say it goes to trial. Do you think that the defense will be able to find experts who are able to, kind of maybe cast some doubt on the tool marks in this situation? Or is that kind of a budding field of people who are skeptical towards it?
No, I don't think there's going to be any problem finding an expert.
So we may get a dueling experts trial here.
We may, but if they are hinging their case on this one piece of evidence, they're in a lot of trouble anyway.
Yeah, I'm curious if you could speak more to that based on what you were reading in the probable cause affidavit.
Well, it's interesting to me, and I, as I mentioned earlier, I haven't necessarily read it with a fine-tooth comb, but I don't think any witnesses are there. I don't think there's any claim that witnesses identified him as the person they saw out there that day. That seems kind of interesting to me, that no one has been, according to the affidavit, no one has been shown a photographic lineup. I mean, in any old run-of-the-mill homicide case that I deal with, they've been shown multiple photo lineups a lot of times. That is certainly something that has happened, but they didn't talk about it in the affidavit. So, it raises a question in my mind. If they didn't do it, well, why didn't they do it? And if they did it and didn't mention it, is it because they're trying to keep that out of the public eye for some reason, or is it because the people identify someone other than Richard Allen? I wouldn't be able to know, but I suspect that there's a lot of other evidence and that exists, but that was left out of the affidavit, and that they're using this particular piece of evidence as the linchpin to get the affidavit to get him into custody. And I can talk about why they would want to do that if you want me to. Why would they hide evidence? Or let me rephrase that. They're not hiding evidence. They're just not revealing everything because they're not required to at this point. And there are good reasons for them to do that.
Can you go into those?
Yep. It could be that there is another person involved, and as the news reports say, that the prosecutor said that he said there are other parties or whatever, his other actors. And it could be that they want to get Richard Allen in custody so that they can put pressure on him to talk about what he knows. Obviously there's a Keegan Kline is in custody, and his veracity is not strongly established so far in the record. And so he may have, there's just a lot of smoke around this fire, right? There were so many things that happened circumstantially. Keegan was removed from the jail, placed into the state police custody, and then a search of the Wabash River ensues shortly thereafter. All of that sort of thing strongly suggests there's a connection to all of the activities. I mean, for 4.5, 5 years, nothing happened. And then all of a sudden, all of these things start happening. It seems like they've got to be connected because of their temporal closeness. So maybe Keegan Kline or someone else has said some things about the facts of the case, and they want to get Richard Allen into custody, not reveal what has been said by Keegan Kline or the other person, whoever that might be. So therefore, it's not published in the public, and then now they can ask Richard Allen questions and see what kind of answers they get, so they can compare them. It's the holdback evidence theory, but it's more directed towards Richard Allen than the public at this point. So that's one good reason to hold back that information out of the.
Yeah, that makes a lot of sense, and it's going to be interesting in your experience doing criminal defense. Does the fact that there are other names possibly floating out there, as well as the fact that you have law enforcement and the prosecutor essentially saying, we're looking for other actors, we're looking for other players, there's more tentacles to this, is that problematic from the prosecution standpoint, or is that can that be typical when you maybe only have enough to go after one person to start?
If the prosecution or law enforcement are saying there's someone else and they don't offer proof about that, who that other party might be or why it is that they've not been arrested and being prosecuted also, that's trouble for the prosecution. They need to, if they're making those statements publicly and they don't offer proof about it somehow at a trial, that spells trouble. So to me, that suggests they're not just saying there might be somebody else. They are quite confident there's someone else involved, and what that plan is for prosecuting that person or those people, we don't know based on what's available in the public. But if there isn't someone else, as a defense lawyer, if I were representing Rick Allen, I would be all over that. They think it's somebody else. This would be the message I would be sending to a jury. They think it's somebody else. They said it from the beginning that there was somebody else involved, but in reality, my client wasn't involved at all. They know there was somebody else, and yet they didn't bring anybody else into court. They didn't offer proof about who this other person was or what connection they may have had to my client. It is very problematic for them if they are publicly identifying the possibility of another suspect and not prosecuting or linking that other suspect to the defendant who's going to be on trial.
Right. It's a very major loose end, I imagine, from putting a narrative together for a jury.
Yeah.
I'm curious, what sort of things should people be looking forward to happen next?
Oh, well, I don't practice Indiana law, so I don't know procedurally exactly all of the next steps. But I would be surprised if we get to the point where there's a trial. I doubt it's going to be in March, but whenever it is, we're not going to get to a point where there's a trial and another suspect has not been named publicly. That would be something that has to happen at some point. In my opinion, I think it has to happen. Even if a deal has been struck with that other person, there's going to have to be some kind of acknowledgement, whether it's in the form of a press conference or press release, or more likely a filing of some sort in a public record. I think that has to happen in order for it to kind of be cleared up a little bit as to the confusion regarding what happened in this case and how we got to the point where a previously unknown person has been charged and no connection to any of the other players that have been mentioned so far publicly. There's got to be some connection made, and that's what that's going to be the next big step, in my opinion. That's going to be the next big action that happens in this case.
That makes sense. Moving out of the trial realm and more onto your experience with firearms, we wanted to ask you, so Mr. Allen is said to have a Sig Sauer P226. Do you know anything about that gun or what sort of that conjures to mind for you? Kevin and I, we don't own guns and we don't really know them that well, so I feel like we'd be curious about what someone who does has to say about like that kind of gun.
I don't have enough experience with that particular brand to know anything in particular that it would say. I mean, it's a handgun. It's a fairly commonly sold handgun, and so it's just the sort of thing that somebody would that wants to buy a firearm for self protection or protection of the home, or that's the sort of thing that they would buy. It's not like some sort of automatic or weapon that would be prohibited by law, but or some Uzi type thing. So it's not going to be something you're going to see on a movie and say, "Oh wow, that's an interesting gun." It's a handgun. It's just a standard handgun, basically.
That makes sense. That's very helpful. So it's not some sort of rarity.
No, it's not the most commonly sold handguns, and I'd have to look into that to know, but it's not rare.
That makes a lot of sense. And then I guess just as you're observing this, any other things that have stood out to you about either what the prosecution or the defense is doing so far that seem kind of noteworthy or worth discussing?
The defense side is strongly asserting actual innocence so far, and that's what I would be doing. Generally I don't give interviews, but I think they're in the position where they kind of have to. And so, it's pretty noteworthy to me that they are as strongly, taking that position as they are, and that Rick's family seems to be behind him. That's very interesting to me.
Is that unusual for a defendant's family to stand behind him in a case like this? In cases that I handle, it's not terribly unusual.
But this is not a normal case. This is a once-in-a-career kind of case. I don't think I've had anything like this personally. It would, the fact that his defense lawyers mentioned that his wife is behind him means that that's probably true. I don't think she was, there's varying reports as to whether she was there or not. But in a case like this, so high profile and it's of such an important nature, the facts that are alleged, it is somewhat surprising that there's a mention that she's supporting him. I would suspect the more likely course of conduct for family members is to not be involved terribly in the defense, but not necessarily being, they would, for example, Tony Klein giving his son money, and is contacting him all the time. That's the reports are to be believed. That's the sort of thing that I would, but doing it quietly. That's what I would expect. But for them to be, for the defense lawyers to feel confident enough in her support to mention it, to me, is noteworthy. And what does it mean exactly? I don't know. But it's noteworthy.
That makes a lot of sense. And you mentioned the defense asserting actual innocence. I'm sure for a lot of lay people, that might just seem like par for the course for a defense attorney to do, kind of say, no, my guy's innocent. He didn't do anything wrong. But I'm curious, in your experience, what makes that somewhat unusual?
A lot of times there are defenses that kind of suggest themselves from the facts. You may have a self-defense claim. You may have an accident claim. There are all kinds of legal defenses that you can raise. But to say actual innocence right from the start, you're kind of staking a claim that you better have some facts to make stick, or else you're going to look foolish later on. That's why, to me, the better course of action in my cases is always to say no comment. But these guys are in a position where they're having to respond, and the fact that they went out on that limb and said actual innocence, not those words exactly, but the fact that they've raised that as a defense is a big statement. It's a big claim, and either they know something we don't, or they're just trying to bluff so that they can get the public reaction to quieten down a little bit and actually consider whether maybe Rick is not guilty.
And I would imagine, not to put words in your mouth, I imagine that is important in such a high profile case to kind of, for the defense to at least make overtures to the public. Is that fair to say?
Oh yeah, it's huge. In order to have a fair trial, you have to have people who will consider and who will say and actually consider whether he is not guilty. And so you've got to put that out there that, just because there's an arrest and just because there's all this excitement doesn't mean that our client is guilty or not. It's, public, press releases and press conferences do not make a prosecution. It's evidence. And so I think that is a very big step to take to protect your clients. Now, and I've done it on multiple occasions after trials or after guilty pleas. I go to the press and say, that my client is not the monster that he was made out to be, and you can see it based on the evidence that came out. This was, a bad situation, and that's more of an act of cleaning up my client's reputation a little bit. But if I were placed in their position, I would want to put my defense out there as early as I can, and still leave some flexibility. And the problem with the actual evidence or actual innocence theory is there's not a lot of flexibility from that.
Right. You either did it or you didn't do it, and
Yep.
That makes a lot of sense. Yeah, and it seems like almost setting up another hurdle for themselves to be kind of, proving that he's actually innocent rather than just creating reasonable doubt.
Exactly.
Well, listen, this has been incredibly insightful and helpful to us for understanding this bullet evidence, but just also kind of looking at things from a strategic perspective overall. We really, you're self-deprecating, but you are an expert, obviously, and we really
appreciate it.
We want to thank this attorney for coming on our show and sharing his expertise and his opinions. And again, we welcome other experts to come forward and speak with us. We're always looking to expand our knowledge base on the various aspects of this case that come up, and we're very much interested in hearing more perspectives. So email us at murdersheet@gmail.com if you have something you want to chat with us about, or if you're a listener who's curious about an aspect of this case that you'd like explained by an expert.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.